Well, the Supreme Court's been busy in the last few days. I wanted to mention one decision that I'm not happy about, another one that was a great decision, and maybe even get on to a third decision, which was from just, I think, a week or maybe 2 weeks ago. But yesterday, the Supreme Court, the U.S. Supreme Court, struck down a Louisiana law that essentially said that for abortion clinics to function in the state, you had to have a doctor employed at the abortion facility who had practice privileges, admission privileges at a hospital within some geographic distance. The basic point was to make sure that abortion facilities or institutions that provide abortion have doctors there who can actually do something, help when something goes wrong, and get to a nearby hospital because they have admitting privileges. But the Supreme Court struck down that law, Louisiana law, 5-4. But I want to tell you what I really think is the issue that matters to talk about in this arena. Number one, the Supreme Court addressed a very similar law that passed in Texas in 2016. Texas, very similar law. Abortion clinics had to have doctors working there, at least one doctor had admitting privileges in local hospitals. So at that time, in 2016, when the court was looking at the Texas law, Chief Justice John Roberts ruled with the dissent, meaning he ruled the majority struck down the law, saying that it was unconstitutional infringement on a woman's right to abortion. But at that time, Justice Roberts voted in the dissent. He voted to say, no, this is not an unconstitutional limitation on the right to abortion. So now 4 years later, this Louisiana case went up before the Supreme Court. I'm guessing a lot of people thought, well, now that we can predict how the other judges go, we've had some turnover in the court, we'll probably have this law in Louisiana upheld, because everyone assumed Justice Roberts, who thought 4 years ago that such laws were not an unconstitutional infringement on a woman's right to abortion, would stay with what he said. But what he did instead was Justice Roberts, ruled with the majority and struck down the law from Louisiana under the idea of stare decisis. I'm not going to go way off on stare decisis, but the basic point of this doctrine of stare decisis is that courts, especially the Supreme Court, should follow existing precedent so that you don't have the legal system become unpredictable, that you don't have the Supreme Court saying one thing one day, next thing the next day, and so you never really have a settled sense of law. There's a good and right place for the concept of stare decisis, but stare decisis is not a constitutional requirement. It's just a facet of the Supreme Court. One of the most famous examples in all Supreme Court jurisprudence where a Supreme Court reversed a previous Supreme Court ruling was way back in the era when you had the decision of Plessy versus Ferguson, which was a Supreme Court decision that had said separate but equal is fine, is constitutionally permissible. Separate but equal facilities for people who are black versus white. Plessy Ferguson said versus Ferguson case back in 1896 said, oh yeah, that's fine. Separate but equal meets the constitutional standard of equal rights. Fortunately, in 1954, the court reversed that in Brown versus Board of Education and say, no, actually, that's crazy. Separate but equal is inherently unequal, and that we must simply reverse ourselves. So I'm getting around back to this whole abortion question and Justice Roberts. This case gave him the opportunity to stand with those who were essentially not committed necessarily, not long-term committed to Roe versus Wade being the law of the land for the rest of time in America. The laws being passed in Texas, Louisiana, and many other states challenging the right to abortion, trying to put restrictions on abortion, are ultimately going to get America to the place where there's going to be an issue squarely presented to the Supreme Court. Was Roe versus Wade wrongly decided? It's going to come to that someday. That was not the issue in this case. It was not the issue that any of the judges should have been addressing in the decision that just came down. But it is obviously the burning out there waiting to be decided. Will we have at some point a reversal of the Roe versus Wade decision and re-examine whether the Constitution actually protects a woman's right to have an abortion? Obviously, that language is not in the Constitution. It was a concocted right that came out of a very liberal court. So I'm not as troubled by Justice Roberts right now as I will be if we get around to that ultimate decision about Roe versus Wade, saying, was this correctly decided? Because the answer clearly is Roe versus Wade was a decision, it was legislating from the bench, it was a policy decision the Supreme Court believed in and put through, no constitutional basis for it. The issue about abortion will end up ultimately, if Roe versus Wade is reversed, back in the hands of the legislature. If all states, all 50 states, or 51 if Washington, D.C. gets their way. But anyway, it'll end up back in the state courts, state legislatures, where elected representatives in every state will look at the issue and decide it. So disappointing, really, that Justice Roberts, he seemed, in my view, very much trying to, as he did in the Obamacare decisions, very much trying to make the trendy, politically correct Washington insiders crowd decision. I don't know him. I don't know his motives, but I think that the decision really was, he did not have to follow, he did not have to say, due to stare decisis, I'm going to go ahead and strike down this law in Louisiana too. He didn't have to do that. That was almost a policy decision. Very disappointing on his part, and very disappointing those who are trying to find various ways to limit abortions in all 50 states. One of the quick decisions out of the Supreme Court that was a very positive thing was the Supreme Court rejected what has been come to know, people understand as the Blaine Amendments. It was a case out of Montana involving religious schools, and basically the court said if the state of Montana or any other state has money or resources available to private schools, not just public but private, you can't discriminate against religious schools. It was a long process in American history. We got to the point that states felt like, or states were justifying, they would even permit resources of various kinds, state money and resources, to go to private schools, but not religious schools. And it was really, at the time, targeted at Catholic schools. But the Supreme Court made a good call on this one, saying, you know what, you just can't discriminate against religious schools if you're giving money to other private schools. It was really a protection of religion, a recognition you shouldn't have law that discriminates against religion as compared with other similarly situated schools. I will tell you that no, this first five today was a little bit wonky, a little bit down in the weeds of Supreme Court jurisprudence, but it really is important for people following the court and people following the idea of what is a right in America, what is a privilege. The policy discussion we need to be having is very important to understand how the Supreme Court tackles these very tender issues, including the one that relates to the effort in Louisiana to limit abortion facilities, to requiring them to have a doctor on hand who actually has admitting privileges in some local hospital, so that when things go wrong, you can actually protect the life of the woman. We'll talk more about this another moment, but I want to wrap up the first five by saying it's really important to follow the Supreme Court, and we do in this show very often. We've had many people assuming that because President Trump has been so successful in appointing judges to the Supreme Court, and he's gotten 2 in, which is a lot in his first term. He may even have, I guess time is getting short, but there's hope that he would have a potential another slot open the Supreme Court to fill. He has done a magnificent job. President Trump has filling the court benches and the federal trial courts, the district courts, the appellate courts, and it's an effort to bring the courts back not to the conservative versus the liberal side, because that's not the goal of judges. It's to bring the courts back to compliance with the Constitution and following the law, rather than use the courts, as the left often does, to push through unpopular policies to get their way when they can't get their policies passed by legislatures. It is trying to get the court back to following the Constitution, not legislating from the bench, not putting in place through decisions left-wing policies that leftists in this country want, but that are not actually being created by our representatives in Congress. And that, my very fine friends, is today's First Five.